Welcome, everybody, to the Lawyer Show podcast. I'm your lawyer, Jeremy Rosenthal. Today, my co-counsel is Sean Lemoine. My question for the audience today is, do you love America? I love America. That's me. I love America very much. One of the things I love about America is that I can say what I want, and I can offend who I want within reason. No, I can offend anybody, really, I think. Today, our topic is going to be free speech, and our topic is going to be the First Amendment. That's what Sean does. And so we're just going to kick right off into this thing. I find myself boring, and I know everybody there does too. Sean, welcome to the Lawyer Show podcast. How are you today?
I'm good. Thanks for having me.
You got it. Let's just kick right off. What kind of lawyer are you? What kind of lawyer are you?
Well, I'm a business trial lawyer, and then I have a kind of a side specialty in anti-SLAPP litigation, which is, at least in Texas, it's called the Texas Citizens Participation Act, and it is designed to stop people who file lawsuits to stop what's considered, they're called strategic lawsuits against public participation. That's the SLAPP part of it. And what the statute does is it sets up a mechanism for courts to dismiss lawsuits at the very earliest stages, and it awards the defendant their attorney's fees, and the court can also sanction the plaintiff. So, for instance, if you get sued for running your mouth and it qualifies under the statute, you hire me, I file basically an anti-SLAPP motion, and if we win, the person who was pissed off at you has to pay your attorney's fees and then potentially get sanctioned by the court.
When I was in law school and when I studied for the bar, I don't remember anti-SLAPP. I think this is newer. Of course, I've been licensed to practice now 20 years. That's been another topic of the Lawyer Show podcast. You also have to talk about how long you've practiced and do a lot of name dropping on here. But you told me beforehand that you watched a couple episodes, and hopefully you've picked up on that flavor. I don't remember studying anti-SLAPP. How new is it?
Well, it was first passed, I think, in Texas. The first iteration may have been 2011, possible, or maybe it was 2013. The first state that I'm aware of that instituted an anti-SLAPP was California, and they kind of lead the way on kind of certain novel issues, and so it's started to grow and expand throughout the United States. Texas, I think we've amended ours a couple of times. Most recently, it got amended in 2019 to narrow it back. So you wouldn't have heard about it in law school because it didn't exist back when. Because I graduated in 2000, moved to Texas, and started here in August of 2000, and I didn't know about it until probably 2016 when it started to get some coverage within the legal journals in Texas, and then that's how I got interested in it, and then started blogging about it, and we had some cases at Wick Phillips on anti-SLAPP, and now we've got quite a number of appellate opinions that we've worked on. We've been up to the Texas Supreme Court on an anti-SLAPP issue. So it's an interesting practice area, especially if you like First Amendment issues.
I mean, there's really, if you think about it, there's not a lot of topics that are more, I guess, just that are hot than when it comes to speech issues, because and very public too. You've got all the social media aspects of it. You've got obviously the online issues, which go beyond social media, right? So it's and in criminal law, there are certain issues that have to do with freedom of speech, the ability to limit certain offenders from certain areas. I mean, this is a really, really hot area of law, and it sounds like that's the case for businesses, for litigants, and enough so that you've been able to develop a practice in this area.
Yeah, I mean the for those of us that kind of I would say I more dabble in the First Amendment as opposed to some of the attorneys out there that their entire practice area is First Amendment issues, and they have an understanding of the anti-SLAPP, but amongst First Amendment lawyers, and I guess a small portion of the population, is a desire for a federal anti-SLAPP statute, because in the state of Texas, if we use that same example I just gave you, if the person that sues you in federal court, you're not protected by the Texas anti-SLAPP statute. The Fifth Circuit's ruled that it doesn't apply, and there's a bunch of boring reasons as to why. Whereas the Ninth Circuit has said that the Texas anti-SLAPP statute does apply in federal court. So, for instance, when Stormy Daniels sued Donald Trump, he used the Texas anti-SLAPP statute to get her case dismissed in California and get a couple $100,000 attorney fee award against her in California. If that had happened, that lawsuit had occurred in Texas and been litigated in a Texas federal court, probably wouldn't have applied the
So she should have sued him in Texas in federal court.
No, yes, if she wanted to avoid the anti-SLAPP. I think she sued him. I believe that case started in New York, was transferred to California to the Central District, and then she got kicked out on an anti-SLAPP. And I believe it got argued to the Ninth Circuit recently.
Okay.
But one other thing to the topic that you just raised, you do know about the new bill that Governor Abbott just signed into law.
Of course I do. I know
100%
of everything that they do down there, but why don't you tell us about it?
Well, this one, I believe if you have more than 50 million users on a social media account, so you're targeting Facebook, Twitter, those kind of groups, and somebody just basically discriminates, removes you from the platform based on your speech, you can sue the Twitter or Facebook, and I think try and get your attorney's fees back in like a $25,000 damage. So the state of Texas has kind of intervened in the free speech world and said, you as a private institution cannot moderate people on your forum. There's some exceptions, like if you do something that violates federal law, but if you want to get on the website and promote hate speech or Nazism or whatever it is, and just generally be an asshole, and Facebook kicks you off, you can go and try and sue them now under that law, and say that was content discrimination. You were trying to exclude my political viewpoint of whatever bullshit you come up with, and try and sue Twitter. Now, it's all the First Amendment analysis that I've seen says it's going to fail because of Section 230 of the Communications Decency Act. But, it's Texas, basically the state of Texas, trying to force a company to allow speech.
Right. That was going to be my next question: is how scared are these tech giants of the Texas statutes?
I don't think they're scared at all.
No, I want you to think about this for a minute because.
Yeah, I'm going to check. Let me check my notes. No, they're not.
Okay. All right.
They're not. And the Florida leads the way in a different vein. They passed a similar law. It's already been held up in federal court. I think there's an injunction against the law, and it's I haven't seen any serious scholars that think it will survive a constitutional challenge, because you're basically forcing a company to speak by saying you have to allow this type of communication on your platform. And so it's forced speech is what it is. We're picking a type of speech and we're allowing it. And
but in a big distinction here that I think is really critical for our listeners who are not lawyers. One of the things that I've seen go back and forth on social media, on Facebook and all that stuff, people have to understand Facebook and Twitter, these are private companies.
Yes.
And just like McDonald's can say, if you're not wearing a shirt, we don't have to serve you, a private company like Facebook can say, they can make a rule that the government can't make. They can say, if you want to share the swastika, we won't let you do it here.
Right. Put it another way, I can't come into your house and scream, "You're a motherfucker." Right? I don't have a constitutional right to do that.
That would be fine with me.
You're maybe deserved. Certainly, maybe deserved.
You wouldn't be the first.
Look, if you're not a good lawyer, You're a bad lawyer if somebody doesn't want to do that to you, right?
I'm saying
either client or the opposition.
that's what the Lawyer Show podcast is about.
Right.
Good.
But right to your point, the lack of civic understanding of the First Amendment, to think that that you can go to Twitter or you could go into a Walmart or any other place and say whatever you want and they can't restrict you at all is absurd. Right? It makes no sense, and there's nothing in the Constitution that does it. So every time within there's a group called Law Twitter, like hashtag Law Twitter, which is a bunch of attorneys that kind of dork out, and a lot of what they discuss is First Amendment. And there's a Twitter handle called Bad Legal Takes, which you really have to follow.
They've retweeted me before. Some of my bad. No, I know. Not yet, but I'm worried about that.
The Bad Legal Takes started at the same time there was a First Amendment anti-slap case that I was involved in that got some level of play in the media, and it started at the same time. And I want to say it started with one of the quotes from that case, but you know, invariably the same people who are virologist scholars are also legal scholars, who are also engineers that go on there because they've seen something on YouTube and they Twitter has destroyed my First Amendment right. No, they didn't. And unless we amend the Constitution, they never will. They will never destroy your First Amendment right. They can stop you from being an asshole on their forum.
Yeah.
And
the government is the Constitution applies to the government.
Correct.
It limits the government from limiting your speech. It doesn't limit Walmart or Facebook or Twitter
Correct.
or McDonald's from limiting your speech.
Yeah. If the government said, Jeremy, you can't go on Twitter and run your yap, that would be a violation of the First Amendment.
Right.
Similarly, if the government goes to Facebook and says, Facebook, you have to allow Jeremy to talk, that is also government interference in First Amendment rights. In this instance, it would be Facebook's First Amendment right not to have assholes like you on its website.
And I told Sean ahead of time, we're making the Lawyer Show podcast PG-13. JP, Kathy, and the Crew Network is a family-friendly network, but they knew what they got when they signed me up. But we're not ruining it. This is PG-13 stuff. Putting our lawyer hat on, I mean, if you think about it, it really is kind of fascinating because the vast majority of First Amendment issues come when the government is the one trying to limit the speech. In other words, if it was the government coming to Twitter and saying, take the Nazis off.
That's right.
That would be a really, really big First Amendment fight.
Right, and the ACLU would actually side with Twitter to say you should allow the Nazis, or you should allow the Nazis to be on there. If the government took that side,
right,
and
but
said,
the government's taking the complete opposite side, which is saying you can't limit anything.
That's right. That's what the state of Texas has done. That's what Florida's done. And the problem they have is that the federal government passed a law called the Communications Decency Act, and there's a section in it called Section 230, which basically immunizes platforms like Twitter and Facebook where they have, where people come on and run their mouth, right? I mean, that if you're familiar at all with the Devin Nunes lawsuits, where he sued the Devin Nunes cow and Devin Nunes' mom, which are Twitter handles. So they go on there. They're parody accounts, right? The quintessential First Amendment right to make fun of our asshole leader.
I pretend like I know this. I actually, it rings a bell. This is a congressman, right?
He's a congressman from Fresno, California.
Okay. Yes, I'm familiar with him. I'm not familiar with the lawsuits, but that's not going to pretend me like
So
keep me from pretending like I know.
He sued a number of people, and he sued the Twitter handle Devin Nunes' cow, and Devin Nunes' mom, which were parody sites. And Twitter, to its credit, fought. Well, one, it's protected by the Communications Decency Act, but you can't sue a Twitter handle. You have to sue a human being that's behind the Twitter handle. And Twitter refused to disclose who's behind the Twitter handle because it's not like a federal security act. It's just somebody out there that's got a great sense of humor, that's ripping on people. And it's whether you're ripping on a Republican or a Democrat or a libertarian or whatever. Twitter's like, it's not our deal, right? Not our job to turn those people's names over because you're offended by what they say.
And not that I bite too much on the slippery slope from their standpoint, they don't want to be in the business of forking over people's identities and names, because it sounds like they would probably be doing it, number one, on a frequent basis. Number two, it's going to keep people from signing up and engaging the platform like that.
Right. The purpose of Section 230 was to allow those types of platforms to thrive, because otherwise they would be buried in litigation. Right? Just buried in litigation. You allowed Bob, who's unknown, to say terrible things about me, and therefore I'm going to sue you because they were able to talk to more people because you allowed that, because your platform does that. And so the Communications Decency Act basically says if the I'm not a 230 expert by any means, although I've used the law before in defending defamation cases, as long as they are not a publisher of the communication, meaning Twitter's making the publication as opposed to Bob using Twitter, they don't have any liability. And that is the big fight that this Texas statute is going to run into. Is there's a federal statute that preempts that law that says, as long as they're not publishing the communication, they're free to remove it if they want. They can just delete your account. They have no obligation to you,
right,
as a private citizen, to allow you to be a moron on their platform. So
it's really when you think about it and you step back, it's really just really fascinating stuff. How the law is kind of structured to enable, with Section 230, it sounds like to enable the growth of these types of platforms,
right,
which with whether you love what's being said or you hate what's being said, I mean, these are very, I'd like to think, very American ideals: parody, humor,
criticism.
Yeah,
I mean, we were founded on criticizing the British government.
Right, and with it comes nonsense, and with it comes misinformation.
That's true.
And with it, it's never going to be just the clean thing that we want it to be. One of the things that I'm never in this position too much when it comes to First Amendment issues, but one of the things I kind of like to explain to folks is, look, how would North Korea treat this person? How would North Korea treat them? Well, North Korea would punish people who say things that are on the fringe. They would punish people who say things that are disagreeable.
And journalists, not just your common sense, not just your everyday citizen,
right,
but people whose job is to be the watchdog and alert the community to what's going on. They would punish and censor them.
That's right.
Sure.
They would hurt these people, and not only does that quell their ability, it puts fear into those folks. It puts fear into that type of person. So really, you don't have anybody doing it, and then the folks who do it, free speech it means nothing if it's not to protect the most extreme, in my view, modes of speech. Because if I am for free speech and I define that to mean that my neighbor, the elderly lady who flowers her garden every day and will never say anything controversial, if all it does is protect her, it really just doesn't exist.
Right. Yeah. I mean, free speech can't protect the speech that you like.
Right. That's right.
It's supposed to protect the speech that you don't like.
Talk about some of the limitations, the legal in the past, and this is law school stuff. Talk about some of constitutional law. Talk about, for everybody, what are some of the limitations? Can't yell fire in the movie theater.
So that you can't yell fire in the movie theater makes the First Amendment lawyers crazy.
Okay, let's have it. Why?
I don't know that I can totally do justice to it, but and I can't remember what justice wrote that, but he over the years he backtracked away from that, and I believe it had to do something. They were trying to restrict communist speech, and the justification used by way of analogies, you can't run into a theater and scream fire and say that, and that starts a stampede and a bunch of people get hurt, and that is unprotectable speech, and that's not necessarily true. That speech has a consequence, which is you can get sued, right? And there can be consequences, from governmental entities, because no right is truly 100% bulletproof. There are restrictions on all the rights in the First Amendment. The First Amendment, and all the within all the Bill of Rights, there are limitations that the government crafts that the courts adopt. So and it becomes more tricky when you get into like hate speech bills and things like that. And I don't, doing defamation law, I don't really traffic in the constitutional implications of what is the scope of speech that the government actually is going to restrict, right? I'm never in a situation where I'm fighting against the government and saying that type of speech should be protected. Mine are they're pretty vanilla. It's you called me an asshole, and I'm literally not an asshole, and if people think I'm an asshole, and I've been defamed, and I want a $1 gajillion,
okay.
And now I've found somebody that's willing to sign their name to that. Here you go. And then normally, if it's in Texas state court, normally it's looking at an anti-slap, or the statute has been narrowed back quite a bit now.
So that brings me to this question, kind of more focused on you, Sean, is what's the most common predicament, Pickle? What's the tell me how some of your cases work. What type of clients come to you, and what type of problems do they have when it comes to anti-slap?
So it's usually it's the flip side of the coin for me. Sometimes it's a company that comes to me and says, Jeremy's on Yelp again, and he's talking trash about the company, how we're terrible, how we do this, how we do that. We want to sue him. And I'm like, well, you could do that. And have you ever heard of the Streisand effect? Do you know what the Streisand effect is?
Let's have it.
So the Streisand effect is a story about Barbara Streisand, I think, getting pissed off and maybe suing somebody because she didn't want them saying certain things, and then it just explodes, right? It gets especially nowadays in the media, it gets into the internet, it gets on Twitter, and now everybody and their mother knows about whatever it was that Barbara Streisand didn't want to know.
Got it.
So the joke amongst First Amendment lawyers is, have you ever heard about? Are you ready for the Streisand effect? Because that's what happens when if I go to the client says to me, all right, we're going to sue Jeremy. All right, so now we're ABC Corp suing Jeremy, and we have to defend against what Jeremy said is defamatory. And then Jeremy goes and he posts on Twitter, I'm being sued by ABC Corp because I talked about what a shitty company they were. And then it just goes out.
Right.
The funny thing on law Twitter is you will see these terrible First Amendment cases and just the demand letter. Like, if you're going to write a letter to tell someone to shut up, what I tell the client is, you need to be prepared to defend that letter in public, right? You need to be prepared to defend that letter in public. And a lot of times my default advice is, why don't we try and solve Jeremy's problem? And instead of sending him a letter that says, and if you don't remove this immediately, we're going to sue your ass into the ground, and I trust you understand the seriousness of this letter. All right? If you're going to put that out into the world, you're going to have to be able to defend why you did it. And how much money is Jeremy's nonsense costing you? Because the defending of the lawsuit is going to be expensive. You got to figure out what your damage actually is, which is usually problematic, especially if you've got 20 other Yelp comments about your company not being good, and it's going to get blown up all over the place. I mean, I cannot tell you how many lawsuits get picked up by the media, and people make fun of the company that filed the lawsuit, and then they've got to back up.
Sure.
Right. So that's one side. But there are legitimate times when people go on to onto these platforms, not for good reasons. They lie, they make things up, they over-exaggerate. And those have to be dealt with, but you just have to be tactically smart how you do it. And then the other side of that is, I'm defending the individual. They have said something. Usually it's on Twitter or Facebook. It's probably not something you or I would say, with our lawyer hats on. We'd be like, maybe I wouldn't have said that. But most of the time it's hyperbole. It's people just being obnoxious. But it's not defamatory. It's not really hurting the company, but the company files a lawsuit or the individual files a lawsuit and then you hire an attorney with experience in anti-slap, because the unique thing about the anti-slap is if you sue me for defaming you, and we're in federal court, I cannot get my attorney's fees back in the state of Texas. If you sue me for defamation in state court, and it falls within the anti-slap protections, because it's no longer just as broad of, it's no longer just Jeremy and I are screaming at each other in the yard and the neighbor walking across the street heard it. That's not really protected by the Texas anti-slap. But if it were, it's the one chance that I, as the defendant, have to get my attorney's fees back from you. And so, one of the things I also have to tell clients is if we're going to sue for defamation, you need to be aware of this statute, and you need to be prepared to pay the other side's attorney's fees if we lose, right? And once you tell them that, then the desire to try and use your litigation might or advantage because you're a company or a person with a lot of money decreases.
So that's an interesting point that you bring up, and it's got my lawyer things tingling. Mike, think about this, and here's a question for you. So defamation, first off, let's start here. Tell the jury, what is defamation and what is not defamation?
Oh, well, man, they write whole treatises on that.
Well, we got time.
There's two distinctions. There is a public persona distinction, or what's called a public figure. And public figure a public figure is not just a Hollywood movie star. It can be a Congress person. It can be the mayor. It can be somebody that draws attention to themselves. You, technically, by doing this YouTube thing, are a public person.
Not.
Yeah, you totally are.
No.
So people can say terrible things about you, and as long as they don't know that they're untrue, at the time it's called, God, the law and order people are going to just destroy me for this because I don't have it all completely memorized.
Was this a good time for an advertising break?
Yeah, if you got one.
We don't have sponsors yet, so I'm sorry about that.
Just make some up. You have to make a false representation. Again, for a public person, you have to make a false statement that harms them in some way, and it's got to be truly defamatory. It's like, for instance, the state of Texas, I think defamation is you accuse them of a crime, you accuse them of a loathsome disease.
A loathsome disease.
Or you make statements that harm them in their business profession. That's not all of it, but those are kind of three easy ones.
Okay.
Right? And if you're a public person and I accuse you of having a loathsome disease, all right? So let's say I say, Jeremy's got the clap, right? And has had it for forever.
Can you say that louder?
Yeah. And you sue me for defamation, but you're a public person. So you have to prove that when I said you had the clap, I did not believe it and had no basis for making the statement. And so I say, I read these 3 articles on Facebook that said he's got it. There's 3 women, and they say he's got it, and I have no reason to disbelieve it. And so you lose, right? Because the malice standard requires you to prove that I had no basis and did not believe believe it when I said it. It's a different standard if you're a private person, right? If you don't have a YouTube channel, you're just a dude, in your yard. I accuse you, I make the same accusation. It's a negligence standard, which is like basically, did I have a reasonable basis to say it? And then the key thing for me for defamation, there is what's called defamation per se, where the state of Texas and the statute and common law assumes that there is a harm. So if I accuse you of a crime, I say Jeremy committed rape, right? That is defamation per se. You do not have to prove that you have suffered a particularized harm, right? Now, in order to get damages, you would have to, I can't get a job anymore, blah, blah, blah. And targeting, you've got to be able to target that to the statement and then to the harm. You got to link the causation. Right. But you're entitled to what are called nominal damages, so you could go to court to get your name cleared, right? You could fight it all the way out, and maybe you get $1, and you get some people do this. They go to the jury and they say, Mr. Rosenthal only wants $1, ladies and gentlemen, but what he really wants from you is a statement to the world that Jeremy Rosenthal did not harm anybody, right? And if you got the money or you got attorneys crazy enough to do it for free, you can get there.
Okay.
And so, if you don't want to defame somebody, don't accuse them of a loathsome disease in the state of Texas. Don't accuse them of a crime, and then don't lie about something that impacts their business.
What about this? What if instead of you saying that I have the clap or accusing me of sexual assault, that's a legal statute there. They let's say you just say Jeremy sucks. How about that?
Not defamatory.
Why not? Why? What's the difference? In lawyers' terms, what's the difference?
Well, it's an opinion.
Okay.
Right? How do you prove that Jeremy sucks?
Oh, there's evidence.
Well, yeah, but it's anecdotal at best. But that's it, right? It has to be a statement of basically material fact, something that can be proved as opposed to something that's hyperbole or opinion. If I said Jeremy is the worst criminal lawyer in the state of Texas, because he's never won a jury trial and couldn't possibly win a jury trial because he doesn't even know how to practice criminal law. You're getting close. You're getting a lot closer there because you might have won 20 jury trials, right? So I've made a material fact that you could go
multiply, put at a zero,
right? And
I don't know if that's that many.
So so that could potentially be defamatory, because you have won jury trials, and if I didn't, if you're a private figure and I haven't done my due diligence, then I'm liable under the negligence standard, because all I had to do was Google Jeremy Rosenthal, and Jeremy Rosenthal wins trial here. He wins trial here. He's a great lawyer. Blah blah blah, right? And that particular statement has a material fact component to it, and it impacts your livelihood, your business.
Okay.
Right? And so they can get there, but just Jeremy's an asshole, or he's a moron, or he's the stupidest person on the planet.
Well, I really like this example. You're being very thorough here.
Right. I'm really trying to give people a broad range of Yelp comments.
This has been my favorite episode so far.
That are defensible by any decent anti-slap lawyer.
Very good. Okay, question for you here. So I've always heard, and maybe I'm wrong about this, a lot of employers, right, when somebody's calling and saying, hey, you have an ex-employee here, Joe Blow wants to come and work for me, what do you think of them? That can be a tricky spot. I've always heard that the reason why folks say, well, he is eligible or ineligible for rehire is because that is a factual statement which is verifiable, right? But I've always also heard, and maybe incorrectly, stay away from saying Joe Blow sucks. Now, I know that there's a qualified privilege there too, right?
Right.
I seem to remember that.
Yeah, good memory.
I was.
So there's two potential defenses to that, and you're right. Generally what the company says and what we tell them to say is, we don't comment on that, or something kind of quasi-neutral. But there's the invited comment doctrine, which is I send my resume to whoever, and I say, call Jeremy, he'll vouch for me.
Okay.
I have now invited your comment. If you take a big dump on me to the employer and I don't get hired, I can sue you, because anybody can sue anybody for anything, but I'm going to lose because it's the invited comment doctrine. And then I think there's a specific kind of common law protection for what you're describing, where if somebody is asked to comment on something, as long as they comment truthfully, they're protected. But then truth is variable in the new age, and you can spend a whole lot of money trying to get to what is the truth, that just makes it brutal for everyone.
I thought before today that I had the most fun practice anywhere, because I get to sit down and write jury selection about clients who are running from the police and down an alley and driving a car and going over a fence and being in a swimming pool. But man, I don't know. This seems. here's what intrigues me about this. Tell me how on or off base I am about this. I would think then that you are litigating an incredible array of just different scenarios, because if somebody comes in and says, this guy says I'm the worst chef in all of Dallas, you got to, Sean gets to go in and you probably have to learn what are the ingredients to this type of dish and this type of thing, and what's the reputations of other restaurants. If somebody else comes in and says, this guy, these people are saying that I ran their accounting firm into the ground, bang, you've got to learn that stuff too. It sounds very, very interdisciplinary.
Yeah, I mean,
is it?
And that's not just associated with Antislap, but it's just kind of with business litigation. Whatever dispute. I mean, is it an oil and gas company? Is it an accounting company? Is it a cookie company? We've had cookie disputes over the recipes and things like that. So I've had lots of crazy disputes over the different types of companies. Unfortunately or fortunately, those fights always boil down to money, right? And so to me, the people who have the best stories and the attorneys that I can hang out with and just never say a word, because I can't compete, are criminal lawyers. I mean, by far and large. And like sometimes, I don't know, do you know Brady Wyatt? Mm-hmm. Right, so Brady Wyatt's a good friend of mine. And every now and then I will bring a client and we'll go have lunch with Brady, just so that they can hear the stories.
Some stories.
It puts perspective on their legal dispute when you go through the
here's what could be happening to you.
Here's what guess what little Bobby did, and he's down in juvenile for doing X, Y, and Z. And you're like, oh, that's a breach of contract, and not really as serious. Or this Yelp review doesn't sound that bad, kind of
One thing I will say about criminal law as it relates to social media platforms like Yelp and Google, it's very hard for us to get a really good Google review. We can just crush a case in court, we can win it, but man, people are very hesitant to say, Jeremy Rosenthal is so great, he got my fill in the blank, right? DWI, domestic violence charge, rape.
Yeah. Acquitted on double murder.
Yes,
Right,
exactly.
yeah.
Boy, they thought that I was a, Boy Scout master for the reason of this, and they charged me with the crime, and Jeremy got me off. Nobody. Although we do get some. Heidi is our office manager. We should have more than that. We have a lot more. We have a lot more happy clients than just that, but I get it. It's a challenge. So, okay, what is something every lawyer ought to know about anti-SLAPP in Texas?
At a base level, that it exists.
Okay.
Right. That's the first one. And that, it really applies to First Amendment cases in like business disputes, because there's some really tricky parts as to how it slides into impacting certain types of businesses, and it's been applied to like legal malpractice cases and things like that. So there's some people that get surprised, like even in real estate disputes, because there's the right to exercise of free speech, there's a right to exercise your right, or the exercise of right association, and then there's an exercise of the right to petition. And so, for instance, I know I'm not answering your question, so if you sue me or statements that I made during the course of litigation, you want to sue me for legal malpractice. Sean stood up in court and he said these stupid things and we lost the case because of it. I can actually anti-slap that claim, because I was exercising mine and your right to petition when I made those statements in court. And you're now suing me for the communications I made in court. I now get to anti-slap you. And so your legal malpractice claim now gets sucked into the world of anti-slap. And defending a legal malpractice claim, you can't get attorney's fees. But now that I've anti-slapped it, I can get attorney's fees. So you get the double indignity of losing your business case, trying to sue me because it was my fault, and then getting to pay my attorney's fees. So and that happens, and it's not a pleasant thing. But
I just want to say, thank God you use your powers for good. I
think that depends on which side of me you're on. But what they all need to know, besides that it applies, is how to properly counsel the client, because clients aren't used to being the aggressor, like in the legal malpractice example, and then turning around and having to pay the people that they're suing their attorney's fees plus a potential sanction.
That's fun. That's the whole reason why you practice law. I mean, is to get, I was first kid on my block to file a motion for sanctions. I did civil litigation just for a year or two amongst the big 20 years that I have been practicing law. We haven't name dropped at all. Oh yeah, a little bit, Brady. So that was good. Kudos. That's a point for you there. Let's shift. They only let us do this for an hour because they're smart.
That's all you need.
They're smart and they know to cut us off. I do want to talk a little bit about you individually, and I'm curious, kind of a couple things. I want to know how you got into the space that you're in, because this is probably. I'm just kind of curious as to how you got to be the anti-slap guru. I want to know kind of how did that happen? How did you land in this area?
So I wouldn't call myself a guru. There's some attorneys in Texas that really know the statute well. But how I got into it was in 2016, we started to see a shift of anti-slap claims being applied to business disputes. So, for instance, I will give you a good example. This one went to the Supreme Court. A guy is working for Exxon. He goes out, checks some wells. The wells, he says, okay, they're fine. Two guys go in behind him. They check him and say, he missed this, blah, blah, blah. And the tanks could have exploded and killed the world. I'm sure it read like that.
No, I'm sure it read like that. I mean,
he sues Exxon, and he sues the two people that came behind him for defamation. I think maybe tortious interference, whatever. And the crafty defense attorney, Antislap, didn't said that's under the way the statute was working, that was a right of free speech. It impacted a matter of public concern via environmental health and safety, because if these things exploded, that would be bad. It goes all the way to Supreme Court. Supreme Court says, yeah, it does. The speech that's protected under the statute does not have to be public speech. It's not me out being the town crier yelling about a congressman. It can be a private matter that has broader implications. Well, when those sorts of cases started to percolate, I was like, that's an interesting defensive strategy for business disputes, and we have to learn that because we don't want to be stepping into that for our clients, where we file something and we get hit with an anti-slap. And so I started circulating cases. In 2016, the first time I maybe circulated a case through the firm. And then my wife's she's a healthcare lawyer. And so I would just babble on to her about it. And she finally goes, one night, she goes, would you stop talking to me about this stupid statute? Why don't you start a blog? And I sat there for a minute. I said, well, that'd be awesome. And so I started blogging about it. And I started, I think, you can go, maybe 18, maybe 19. I think it's been like 2 years. And I blogged about it, and just, there's a case that got applied to whether or not you can put a chicken coop in your backyard, and that blew up. And
Can you?
It depends on the homeowner association's regulations. And so there's all kind of crazy cases that get sucked into this anti-slap world. There are business disputes, whatever. And so that was why the statute got revised in 2019, because it was clogging up the Court of Appeals. And this is like some serious nerd shit. If you file an anti-slap motion and the court denies it, I have an automatic interlocutory appeal that freezes the case until the Court of Appeals decides it. So you sue me for defamation, and I file an anti-slap, and I lose. I file an appeal. The moment I file an appeal, the case shuts down until the Court of Appeals renders a decision.
Okay.
And so you're looking at 8 to 12 months. The case is just going to cold storage.
Yeah,
you cannot do anything. The court cannot.
Okay.
Right,
yeah, you did a good job of explaining that, because that's like, here you are, we filed the suit, we won our trial, which is right here, and the interlocutory appeal.
Right, 12 to,
and then for a long time.
Pre-COVID, I would tell a client 12 to 18 months, and the moment you put that anti-slap in the middle of it, it goes from 12 to 18 months to, 30 to 36 months because we got to go when the anti-SLAPP appeal then come back and the case starts.
So what did the statutory change from 19 do?
The primary thing that it did was it narrowed what's called a matter of public concern. Under the old statute, the matter of public concern was very broad. It could deal with health, safety, and community well-being. Well, shit, what is that? That's pretty much everything. And that's what some of the courts said
Right.
was it's everything. And then some of the Court of Appeals, there were lots of dissents written by the justice saying there was no thought put in, basically there was no thought put into this. It could not possibly apply to a breach of contract case or a trade secrets theft case. And so the legislators went back in and they said, all right, matter of public concern has to be, something that the public is talking about at large or something that affects community well-being. And they actually, in the legislative history, talk about the Snyder v. Phelps case,
Okay.
which I'm sure you're completely conversant with, which is...
We just were talking about that on the way, Heidi
right,
and I.
which is the Westboro Baptist Church going to veterans' funerals and being assholes. And so they got sued. I think this case came out of Wichita, Kansas. They got sued. It goes all the way to the Supreme Court. And they got sued. I think they got hit for $1 gajillion. And Justice Roberts wrote, and he basically said, there's lots of offensive shit that is said and done in the world. And what these people are doing is awful and terrible, but it's not, but it's a matter of public concern, right? The impact of the war in Afghanistan and the right to protest that and all this other stuff, we need to protect that with the First Amendment. And so what the legislature did was they tried to engraft that into the statute. So the right of free speech is now relates to a matter of public concern. The right of association relates to a matter of public concern. And so
Right.
it is no longer people mad at Jeremy on Yelp
Yeah.
and complaining about his legal practice.
Well, or a landlord tenant. I mean, I could say that my landlord doesn't provide heat in the winter, and then he can say, well, that's a matter of public concern because everybody needs heat in the winter, and
Right.
and so then you just have a really mundane dispute that is sucked up into the statute, and then if I have enough money, what we call in the legal industry, if I have a bunch of fuck you money, we can do our interlocutory appeal, and I can shut this whole thing down for however long.
Yeah, there's nothing better than explaining to a client the appellate process to anti-SLAPP.
This is fun.
We're going to beat this anti-SLAPP motion, and your case is going to go to sleep for a year.
This is man. See, this is what lawyering is. This is good stuff. Yeah, that's what makes this fun, is to be like, all right, we're going to take a monkey wrench and we're going to shove it right in the spokes of your bicycle.
That's right. We're going to get it. We're not in the spokes. We're going to put it in the engine and just let it clatter around and
There it is.
See what happens.
There it is.
Right.
Watch you fall on the ground.
Maybe you're alive in 12 months. I don't know.
Hey,
we don't
whatever.
know.
We can't control these things.
Right,
Let's
right.
make sure the retainer's kept up.
That's right.
Get a pellet in here. I get it. Okay.
So, but the short answer is my wife.
Okay.
The reason why I
she was
blog,
like,
why I
enough of
blog
this.
is my wife. She's like, enough of that. And I started blogging, and then I've got like 200 people that are subscribers to the site. But much like the shows generate business for you, I've picked up clients because of it, because they read it and they like the way I write, or they think I know what I'm doing, and so I get hired by it. Right now I'm kind of really only blogging about Supreme Court cases, because there's been, I think, 18.
Is that
written
right?
on the Texas Antislap. Oh yeah, man, it is a nightmare. It is the greatest gold boom for appellate lawyers since when they invented the summary judgment procedure first. And so I have an update. I get an update every day on the Antislap. I read it and I'm like, garden variety. I don't care.
This doesn't move the needle.
At first I would blog about anything, literally, in case it came out. But now it's really got to be funny. It's got to make me laugh, or it's got to be something that's unique that nobody's seen before.
Pretty significant. There is a major. There's a big. And again, not doing First Amendment stuff. There's a really big Supreme Court opinion. I don't know how familiar you are with it. I believe it's called Packingham versus North Carolina, and this is and it's a criminal case. It basically says the internet's for everybody. And there was the facts of it is there was a sex offender who was done with his whatever, paying his debt to society, he was done. But he was, I think, a registered sex offender. North Carolina said registered sex offenders can't be on Facebook. He gets a traffic ticket. Guy gets a traffic ticket, and he wins it, right? And he goes online and shoots everybody the double birds and says,
right,
then they hit him with this violation of, well, you're a sex offender, nanny, you can't be online. It was an 8-0 opinion. I think it was in 2017, so maybe Gorsuch was not yet, he was nominated, not yet sworn in or something like that. So it was an 8-0 opinion, but it basically said, no, the internet's for everybody. Social media is for everybody. You cannot, it really, really limited the ability of the government to take even offenders off. And they basically rationalized it, said, they said in the 21st century, Facebook, Twitter, Instagram, these places are the town square.
Right.
These are the courthouse steps in the 21st century.
This is where the town criers go.
That's right. And so in cases that I've had, excuse me, in cases that I've had, I'll ask probation officers or law enforcement in cases like this, okay, so are you saying that my client can, if he goes and criticizes fill in the blank, Joe Biden, Donald Trump, Ted Cruz, you're saying he goes to jail if that's what happens here? Okay, Your Honor, I don't think we can do this.
Right.
You still get pushback from it. I'm sorry, I'm having a hard time here today. I wanted to ask you about the West Nile virus. That's something that is very important to you. We do have a few minutes left. While I cough, I don't know what happened. I think I'm okay. While I'm coughing, go ahead and explain to us. Talk about the West Nile virus and
there's nothing,
and the amazing things that have happened to you.
There's nothing better than being in the middle of a COVID pandemic.
Oh.
Being immunocompromised from West Nile and having some asshole sit across from you and start coughing.
Coughing in public is the new farting,
right.
Just so you know. I'm vaccinated. And
as am I.
Okay, well, very good. So statistically, this is...
Yeah, statistically, I'm the only one that's likely to die from this.
I will let you know. I don't know what... I'm sorry.
Hey.
I'll go cough on. I'll go cough over here.
The epitaph will read, and he died on some asshole's YouTube show. So... So 2009...
Okay.
2009 was the busiest trial year I'd ever had. I tried a 3-week trial in California. A jury trial we won, 2-week jury trial in federal court. We lost, and in a 5-day arbitration in Atlanta that we lost. So not the greatest year for my victories, but good from, I was a 9-year attorney, and so I have 2 big jury trials and a big arbitration under my belt. Was working outside my house in East Dallas one day with my 3-year-old son. Lots of mosquitoes. Took him inside, sprayed him off on it, and I left him inside. I said, it's just too bad out here. I'm going to go outside, finish work. About 7 days later, I started having blurry vision, head hurt. And, kind of one of the last things I remember is telling my wife, I think we need to go to the hospital because my vision is blacking out and I'm having trouble walking. And so that started the nightmare. They figured out fairly quickly, within about 3 days, using the lumbar puncture, that I had West Nile virus, which is mosquito transmitted. It had only been in the United States since 1999. So I had encephalitis, meningitis, and the virus was attacking the myelin sheath on my nerve system. So basically, my lungs collapsed. They had to put me into a coma. My brain was swelling. I mean, it was all manners of horrible. And so then they thought I was brain dead for a while. And then they finally brought me out of the coma, transferred me to Baylor, and it got worse. The virus continued to attack me, and the neurologist we got this thing, and the Israelis have been using it because they've been dealing with Nile since the 40s. If you can get strong enough, had multiple blood infections. I mean, it was bad, and they said when you get strong enough, we're going to hit you with a dose of it and see what happens. And my sister's a doctor, and she's like, you got no choice. You can't walk. I couldn't walk. I could barely lift my hands and feet. And it worked, and they hit me with a couple more doses. So I was on a ventilator for 6 months. It took me another 6 months to learn how to walk again and, dress myself, brush my teeth. I was a wheelchair walker, cane. now to chronic faller. And so I was out of work from September of '09 to like January of 11. And, to their credit, my law firm, Wick Phillips, was behind me 100%. Yeah, I was the first associate there. We started in '04, so I've been with Brian Wick and Todd Phillips for forever, and they were great to the family. And then I came back, and it took me probably another year. So I think I tried my first jury trial in 12. And then just kind of over time. But I've got diaphragmatic paralysis, so I don't breathe well. The reason my voice sucks so much is one of my vocal cords is frozen, and then I've got neurological damage throughout my body. So I'm susceptible to falls and very weak, but it makes for a good voir dire.
Man, what percentage of West Nile cases? Because my understanding is that the encephalitis, that's what you had.
Yeah, meningitis.
Meningitis, and there's that type, and then there's the type that's like
West Nile fever,
like the flu.
Right, there's a flu.
What percent? How rare is what you had?
I think I'm totally making this up based off some partial memory. I think in the United States, when I got it throughout the entire population, there were only 1,500 cases of neuroinvasive West Nile. And in Dallas, the year that I got it, there were only 17, and one person died. And that one person that died was coming off chemo. It was a kid close to my age, but he was coming off chemo. But in that group of 17, it was me and that one kid. I was the only 36-year-old. Everybody else is usually much older, and they're immunocompromised in some way. Mm-hmm. So there's nothing that makes an immunocompromised person happy like a pandemic.
I'm sorry. Yeah, I was going to say, in all seriousness, I mean, I'm guessing you've been working from home the vast majority of the time.
Yeah, I mean, I was a 1B, so I got vaccinated in January.
Okay.
And the kids are vaccinated. My wife's vaccinated. I mean, we try to be smart, but at the end of the day, there's only so much you do. So for now, I work partially from home and sometimes at the office, and it kind of just depends on what's going on at work.
What's it like? What's that like to miss a year, 2 years of your practice and then try to step back in?
It sucked, I thought it really sucked. But the law firm was great. I mean, just absolutely great. And there was a period of time where intellectually I could not do the level of work that I do now. And we had sat down and we had a conversation, and I said, I'm slow. Like mentally, I am not connecting the dots based on the way that y'all hired me. And they said, we're gonna give it a year, and we'll put you on promissory note cases and breach of leases and stuff like that, and we'll see what happens. And then slowly over time, it regenerated, whatever it is, and my brain started to fire, and so I'm probably as capable as I was prior to the West Nile, with the exception of just the neurological weakness and the breathing, shit like that. Sometimes I get fired up in cross-examination and my diaphragm kicks in, and so when I voir dire about that, I'm like, y'all need to know that I have West Nile, and if I shake, it's not because I don't believe my client's case, and if my breathing sounds crazy to you, it's not because I think something's wrong. I only have one lung that works.
So the jury's there thinking he doesn't believe his client's case. He's not shaking.
Right. It's a double-edged sword. I'm like 50-50 with that foot hour.
Well, sounds good, man. No, that really is a pretty incredible story. Did you have, not to ask too personal of a question, did y'all have long-term disability insurance? Did you have some type of insurance? And that's something that I think that, from my standpoint, in the back of my mind, I've always kind of thought that it really, truthfully, as a criminal defense lawyer, I'm on my feet a lot. I'm at court a lot. I'm making the rounds at the courthouse. I'm doing docket. I'm going 6 different places. If something were to happen to me physically, it would absolutely impact my ability to make a living. Can you talk about that?
Sure. So the difference between us going bankrupt from the loss of my income and the medical bills and stuff like that, and not was the disability insurance. we had a policy through Wick Phillips, and then the financial advisor we used before we had kids said you should get this because, his comment was, in the 20 years I've been doing this, I've never had a client cash out on a life insurance policy, but I've had 20 use their disability policy because they got whatever. And my policy was a trial lawyer policy. It was, if he cannot go into court and try cases, he's disabled. Well, I was fucked. So there was no chance of me trying cases anytime soon. And so that it's we were fortunate enough to be in a position that we could afford it, and we had it. It was purely he recommended it, and we said, yeah, I was like, okay, whatever. If you think it makes it, the logic made sense, right? I'm not going to die if I'm going to die from cancer. That policy kicks in. But maybe I get in a car. One example was, I've had 3 clients get in bad car wrecks, and so the policy was targeted to my ability, not to be a lawyer, but to be a trial lawyer.
That makes a lot of sense. I want to thank my co-counsel today, attorney Sean Lemoine. Talking with Wick Phillips. Do you have a blog site?
Antislaptexas.com.
Antislaptexas.com. I mean, there are fewer topics, fewer topics that are more interesting or exciting than First Amendment stuff. But man, we could have been here for an hour, 2 hours, 3 hours. But I think we're going to go ahead and call this one a wrap. But thank you, everybody. This has been the Lawyer Show podcast. I'm your lawyer, Jeremy Rosenthal. Again, my co-counsel today, Sean Lemoine from Wick Phillips. Take care, and we'll see you next week, unless we don't.